Ladies and gentlemen of the jury, thank you again for your service. And as I said in jury selection, my name is Tracy Waldrop and I represent Ms. Infante. She is the owner of Genrose Properties. And it's true, at the time of when this lawsuit began, she was not incorporated. But you'll learn from the testimony today and from the charges that the judge is going to give you that a wholly owned sole proprietorship for an entity is a legal entity. And you'll learn too that the law has changed and that if documents use the same names that are used in the lawsuit, it's valid. And that if Mr. Norwalk would have raised that objection to Genrose Properties not being a legal entity at the time during the dispossessory hearing, then they would have been given time to amend the complaint. And you'll learn today also that contract, well, the evidence will show that the contract was valid. You'll learn that the language in it is clear and concise, and that in commercial leasing, it's not like residential, where the tenant has more rights sometimes than the landlord, and they're protected. In commercial leasing, you're apprised to have a certain knowledge of business. You're a business owner, and you're leasing a commercial space. So there are things that you can contract for that you wouldn't be able to in residential contracts. And that is towing the cars, locking the doors. And in fact, you'll see in the contract that Genrose have the ability to lock the doors. But you'll hear from witnesses today. My client and some of her tenants are here to testify. You'll hear that Mr. Norwalk did not have just 10 cars. They didn't tow the only cars he had on the lot, and that they didn't tow his cars necessarily just for being late. He had more than 20 cars that day. And you'll learn that all of the tenants, after Mr. Norwalk made an appointment with Genrose Properties to pay them his rent, you'll learn that all of the tenants were warned about their limits of cars because they were all over the limits. And when Genrose Properties came back to the property that night, the only person that had not removed his cars was Mr. Norwalk. And so they started towing. And at that time, he started removing some of his cars. He removed 10 of them inside his building, or some just outside, and called his clients, and they picked up some of them. So Tara Recker took 10 cars. They only took down to his limit that he was allowed in the lease. And you'll learn that Genrose relied on those provisions and that they were allowed to do so under Georgia law, and that Mr. Norwalk was not just in default for late rent and cars over the limit, but he'd not shown he had a valid business license, nor had he shown he had $1 million. And you'll learn that the language is without a doubt clear, and that it is a standard commercial contract, and that most commercial contracts have a more harsh language in them if you're late. But you'll learn from the witnesses today that Genrose Properties is someone who works with their tenants. If they didn't, they'd be out of business. And you'll learn that Genrose Properties takes partial payments all the time, and that they took a partial payment from Mr. Norwalk in August before he was late in September.